stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you and good morning. The first thing on our agenda is the consent agenda, minutes from 8/27. Approval of payroll, approval of vouchers, approve and sign renewed lease for Northwest Healthcare, approve and allow chair to sign malt beverage permit, Field of Dreams.
Move to approve, Madam Chair. Second.
I moved and seconded to approve the consent agenda as listed. Is there any discussion on the motion? Hearing none, all those in favor?
Aye.
Anyone opposed? Motion passes. That's fast. Next thing on our agenda is a continued public hearing, so we'll have to wait a few minutes. Sign.
Madam Chair,
Yes, sir.
if I could, before we open the public hearing, I'd like to state the fact that I wasn't here at the first discussion of the public hearing, but I did review the minutes, and I'm somewhat, I believe I'm familiar with the issue. Considered part of the discussion.
Sign mango.
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 Here he is.
Blazing Saddles.
Oh, here comes it.
Mongo. Mongo.
We're trying to close captioning and instead of mango, it came up mango.
You can see the governor on Thursday. Tried to respond, but no answer. I'll just block you.
I got it. Okay, I think we're close enough. Next thing on the agenda, continued public hearing, Mendoza subdivision preliminary plat. And we had the initial discussion on this a couple of weeks ago. There were some questions as to how to move forward. Commissioners, where do you want to go with this? Jenny, is there any new updated information?
Received dated July 24th from the applicant and addressing all of you. In summary, he just voiced his frustration and the delay of the approval of subdivision due to the road. He feels that the county approved the prior subdivisions and the road was not constructed as it was supposed to be constructed, and maintenance has always been an issue despite the existing agreements that are in place. He said that he is willing to pay for his share, 2 of the 16 lots, that proportionate share of the maintenance, and has agreed to provide a 20-foot easement north of Barrows Road to help fix the road issue on the west side and to preserve the Hanson's home that was built in the existing right of way. And he does not believe he should have to pay for what he believes is the Hansons and the county's neglect, or to fund the construction of the turnaround at the west end of Barrows Road. And I realized I don't think you've been provided this, and we can just leave it as is if you'd like, but Shoshone Irrigation District did respond with the initial canal easement. They said is 100 feet from the center of the canal, or whatever is necessary, which seems to be what the irrigation districts just make that statement anymore as much as needed. But he also mentioned that the 17F head gate and pipeline looks like it has already been addressed, and he confirmed that there are no water rates on the property and there will not be a need for a water distribution plan. And that's all I have. Thank you.
Commissioners?
Just Madam Chair, to bring up, speak for me, the public hearing has been closed.
No.
Okay.
This is continued public hearing. Do you have anything else that we can ask? Anything else for staff?
Not for staff, not at this time.
Is there anyone from the public that would like to address this issue? Come on up to the chair, please, and if you'd identify yourself for the record. Yes.
Donald Hanson. I live out there where, like, you guys know where I live. Oh, I follow you nowhere. Well, you too. Anyways, I just, I read Mr. Cody's letter here that she was talking about, and I'm just gonna make a statement or two here. The delay of the Mendoza subdivision is due to planning and zoning wanting to get this right in the end. The lack of planning and research on Mr. Schatz does not constitute any hurry up to get it wrong on planning and zoning. Yes, there are a lot of mistakes made pertaining to Barrows Road. There is enough blame to go around to everyone, but we now must take the time to remedy these problems as a community with everyone involved to make it right. Barrows Road is a private road with public access. The road was built by and for Western Hills subdivision tenants. We believe that we own the property, for there we have the right to say how, when, and where any maintenance or accelerations. Come on, Don. You know what I mean. I'm sorry. I'm gonna bring. We also acknowledge that the Sullivan subdivision has a clause to pay 50% of the maintenance road. Now that Mr. Sullivan has sold the family exempt parcel of land, it needs to be tied into the road maintenance. The Barrows Road, whether kept as one lot or subdivided. That's what we're asking. For 35 years, the West Hills have maintained this road for several of our tenants on regular basis. Then Sullivan was added by past commissioners. We feel that by our own rules, the road should have been paved or at least brought up to county specs at that time by the developer, Mr. Sullivan. Now at the lower end is in general need of repair. Why and how did this happen? And then you granted Mr. Mendoza not to pave the road or bring it up to county specs for reasons for financial burden on him, so he can make a profit off the road we built and maintained for 45 years. Thank you.
Thank you. Other public comment?
Madam Chair, Cody Schatz with Engineering Associates. For clarification on Mr. Hansen's comments, I did not write that letter. It was the developer. And I feel like I've provided all the information, so it wasn't unclear on what the issues are out there. But I do appreciate that he says that him and his son do own that road, and so they can do whatever they want. So I guess they can build on it. But I don't think that's quite true either. So all I can say is we're another 2 months into this meeting. You've read the letter of what they wrote. None of the Hansons have come forward to say they want to pay for an amended plat. They haven't come forward to say that they're going to working at the end of that road to get that turnaround in the right spot and build the county standards. So I guess we're just another 2 months in. So yeah, my client is looking at not going forward with this development, and then if that happens, then he will not be providing an easement on that road. And I'm happy to answer any more questions.
Anyone else that would like to speak to this issue?
And McConnell with Public Works. I just kind of want to follow up from our last meeting a little bit on the house and how we got that discussion as far as the options besides the plat. And I kind of just went through and looked at several different locations. And probably the one that matches the closest is what we did on Viking Drive. On a road. When you're talking about dealing with an encroachment in the right of way, the Hansons could have the ability to petition to vacate the portion that's being obstructed right now with the building of the actual roadway, and that would just be the typical process of a petition that has 6 landowners or 6 voting individuals from Park County signing that petition. Bring that to you. You guys could make a decision whether or not to do a resolution to vacate. You have to go through the whole process of getting somebody appointed as a viewer or claims for damages, things like that from the other people, neighbors impacted by that, and potentially that could be vacated. And our office, as far as the administrative relief, we're talking about that west 600 feet specifically, and probably the most impacted part of this development and stuff. But our office still feels that the developer working with the other landowners granting an easement, that's probably the best step versus amended plats and things like that, because the developer has the ability to grant that easement. There's no reason for them to do that cul-de-sac, things like that. So really, when you read Ryan's administrative relief, that's still the best solution.
Just a quick question. Fair. For staff, for instance, with this Sullivan subdivision, when they agree to do a road, they don't do it. Do you guys enforce that, or is it a civil matter, or how does that work?
It becomes a civil matter. It's our belief that it becomes a civil matter. The Sullivan subdivision and the Western Hills have documentation of the responsible shore. So regardless of what's going on now, as it is right now, everybody that has that is responsible for the road. So that road. Proportional share of what's happening, and that was kind of one of the things as far as is, I know in Brian's response, those willing to participate. But right now, there currently are people that are on.
I have one other question. When the subdivision was approved, and the plat was approved, whose responsibility is it to make sure that the road gets built where the plat says it's gonna be built?
The way we do things now is different than it was done in 2005, 2013, or whatever. But now, the way things are set up, we go check it. We make their engineer provide a certification that says it's built. And so basically, a lot of the liability falls on their design engineer. That's correct. But in the past, that has not been.
What did they, do you know what they did then? Or
No, I think it was.
nothing? I'm gonna come back up because we need to hear you on the record, Jenny.
I think, I believe there was an affidavit back then, or maybe that was during Western Hills that was signed. And I think that's when the road was put in the incorrect place. But I think at that time, it was an affidavit that the developer would have to sign saying that they were going to construct it as it was approved.
It's not inspected per se, or wouldn't have been
Right.
inspected per se.
And I
Okay.
think that's how they got around.
Okay, thank you. Anyone else that would like to speak to this issue from the public? Yes. Please remember to identify yourself for the record. Thank you.
Hello, my name is Scarlett Mendoza. I'm with Settlement Construction and Lorenzo Mendoza. I was actually co-author with Cody and Lorenzo Mendoza about the letter, but well, I just really want to emphasize that yes, mistakes are made. Like we can't really control that now, but what we do about it is what's important. And we don't want to take anything away from anybody, but we do want to have our property like be our property and like everything done correctly afterwards. So I think it's very important that we all find a position that we can all benefit from in the end, because it does feel like we're financially like using a lot of money and time wise as well. And yeah, I think that is all. Just really want to emphasize that we do want everybody to be somewhat happy with the final decision, but we would like to be heard in our words. Thank you.
Thank you. Anyone else that would like to speak to this issue? Anybody else? Been moved and seconded to close the public hearing. Any discussion on the motion? Done. All those in favor?
Aye.
Opposed? Commissioners? Well, I guess what I was thinking of is both the future and trying to maybe fix some things that happened in the past that sounds like it was kind of a lot of things got involved and a lot of things went wrong. And now we're trying to fix them all in one shot, which is a little difficult. The road being in the wrong place, the house being built in the platted right of way, other structures, that type of thing. I don't think there's an easy or quick way to fix this. I believe, Mendoza's probably have a right to subdivide their place, and I understand their willingness to give the easement. But I do think that for a future record, I'm not sure that an easement's going to do the same thing as an amended plat that would permanently put on the plat where the road at this point to clear up any future, which I understand from our planning office that there is a future of more development using this road because of an open piece that's there that could be subdivided again. So I guess I was thinking about an amended plat for this portion that would clearly indicate how things are. And it would take into account that easement to allow us to move the road where it needs to go. I guess I thought that would be the cleanest in the future. What happens with it's not going to change the obligation of the landowners there, that they're still going to have the same amount of road to maintain and the same cul-de-sac and that type of thing. But it would clean up the record rather than have a plat that shows the road off of where it really is and then kind of an interesting picture in the middle and then an easement, which will just, 10 years from now, once the commissioners look at subdividing that other piece, is going to be another headache and a big explanation of 25 years worth of stuff. So I would like to do the best job of cleaning it up that we can right now. But I also, with the conversations that we just had about when all this happened and what took place and who did what, I'm not sure that the full responsibility falls on the landowners. Because the county approved the subdivision and the road didn't go in where it was supposed to, and the developer's theoretically gone out of the picture, doesn't own the property, so they don't have a right to really do anything with it. So I guess that's where I'm going to stand still as to how we can make this come together using Mendoza's offer for being able to move the road and getting a clean picture for the future. That's what I'd like to see. If that's up to the county to do, I don't know that we can. I guess that's a kind of a legal question as to whether we can work with amending a plat ourselves. But we don't own property there or live there. I don't know. I don't know how that works.
Madam Chair, and my question with this is, what does that entail? Cody might be able to answer, or Jennifer, as to what that entails to amend the plat and the cost, an estimated idea of what that would cost. If the county did, or if we split the cost, any ideas?
Madam Chair.
Loudly?
Madam Chair, Corey Shelton, Engineering Associates. Like we said in the last 3 meetings, amending the plat's only about $3,000. But with amending the plat, that's just the map. With amending the plat, there's still the meeting, so all the stuff to go through. So get everybody's signature. And then if the irrigation district comes in and says, now you have to do water rights, which I don't know. If we're land, water rights for another $5,000 to $7,000 to do water rights on the plat. So it starts, there's a little bit of, process. The map itself is the simple part. We spent more on that in meetings.
How much longer is that delay? 3 months.
Yeah. If not, if it was water rights policies.
If they gave the easement,
Verbiage that says.
the verbiage that says,
Plat.
yeah, then it could be, yeah, then the subdivision could go through with the easement in place, and then the amended plat process can follow and clean up the paperwork.
Question about irrigation rights. That specific piece of property that we're talking about. Not the whole there is, and not on where we're talking there is no water rights. Set out the irrigation rights.
Stand lots 4 feet 50 and have water rights. Lots 4 feet 50. If it touches the property, doesn't matter if it's up in the field or
Within the
if it
subdivision.
touches one of those lots, and the lot's been amended.
So you're saying if it's within the subdivision, it would have to be reviewed.
But
I just say up on that hill there, there is.
But Trent might say, as long as we're not changing the land that has water rights on it, like he's saying, it's down the lower portion, doesn't affect, we're omitting the plat, he might say we don't. And that's happened in the past.
So it's possible to obtain an easement from Mendoza's approving the subdivision and then make a determination on amending the plat in the future.
Madam Chair, if I may ask one of the, I know we're not in a public hearing, but I think everybody has a little bit of blame here, or, you know, from what I understand on this, and it does seem like a negotiated way of solving. Mr. Hanson, do you have a still major issue if they were to give this 20-foot basically to avoid any future conflicts with the buildings that are in the close to the right of way? I mean, would you be happy with this? No, I agree. I'm not saying that, but I'm just saying this would be somewhat of a compromise that would still require a lot of work on our part, Mendoza, but basically puts everybody else in, well, not everybody, because we still have the road maintenance issue that still has yet to come.
There's still a problem with it. This is not remedy. I have no access to my back. Absolutely, I cannot. You cannot drive the vehicle to but you find, I got my own property that I have no access.
Where is that property related to the subdivision?
It is right beside this part. I own lot 12. It's got.
Well,
Or west. Or west. My son owns a lot. But the road would go there. I don't know. With a drop off, where you can't drive off the side of the cliff. I guess it's good.
there are lots in the subdivision and they're not accessible.
How going over private property.
How did that? I'm not gonna- I'm not gonna go there.
The road is up on top of the hill. Yeah, I'd like to know how that happened. That's a good question. Yeah.
Oh. So they put the cul-de-sac here, but the road does have a right to go around that edge.
Oh, yeah, right.
So they. Oh, okay. I got it. Did you see that?
I'm following a little bit, but if we amend the plat, couldn't that be remedied at the same time?
Possible.
This is where the cul-de-sac is. My son. Right here. Okay. This cliff is right here. So there's no place to drive here to get to there or there. Or you gotta go over top of the cliff to get to 12. You gotta go over top of the cliff. Or
Currently?
Currently.
So if everything moved, and let's see, I'm gonna show you.
farther away.
A little bit, but it's still connects. You still have the cliff issue.
Yeah.
One way or the other.
Well, I don't know. Sometime in the future, it take a while to do it, and I talked to several construction companies. That when they get their material from town. Instead of running all the way out to dump out there, they pay for widen that past the 20 feet. 20 feet would give an access, or give us an access to get that dirt fill back in there. And right now, you couldn't get a dump truck back in there.
But
And I agree, Cody has full right to build that road.
and what we're proposing, I don't think changes much of anything. No, because we're just putting the road where it is,
Yeah.
which still leaves you the drop off, but you have that anyway. Currently. So even if we do the easement and amend the plat in the future, you're still gonna have that issue to deal with.
Madam Chair, if I'm looking at the plat correctly, and they move everything to the 20 feet, when we amend the plat, his property line that splits 11 and 12 or 12 and 13 would actually move as well. And we do.
I don't know about that part. We have to
You know,
look
this
at
point
least
here
allowing
would then
access.
have to go to here.
We have to allow access to those lots. However, it would be gone up, would be kind of up to the access.
And the only other thing I'd mention, Madam Chair, is that it will require still the signature of any of the lots affected in the proper, and then Mr. Mendoza. but
To amend the plat.
To amend the
To
plat.
amend the plat,
And I guess
yes.
that's where we're at. Are you willing to sign, because your lots would be affected, to amend the plat to give you access?
The 6 or 7 tenants of Western Hills subdivision that would have to vote to do this. It's not my say. I will say that I own 2 lots. I don't own one. Ryan County has 2. That is both lots. There's the majority of that lot. And talk to all of them people, and all of them say, no. That's basically, I don't want to do it. And I gotta have their permission. Stuff like that. You know what I'm saying?
I do.
It's a quagmire that we can. And I don't blame this guy.
Well, and I think if the county's thinking of doing that, maybe it would be best to reach out to all of those, but I guess Mr. Hanson, if the others did agree to, would you be willing to?
Yeah.
Okay.
I can talk to them, we can talk to them, but I gotta need something. Like Bruce said, there was a proposal, but nothing has ever been put down on paper for us.
Okay, this
We
is,
need something on paper.
okay, the amended plat is a little bit beyond today. The decision today is the subdivision and the possible 20-foot easement to rectify the problem of where the road exists right now. To allow that to work for this subdivision. So I guess that's the first question that we need to answer, and whether we move forward with the amended plat, we would have to sit down with our planning and zoning department and director and possibly the engineer that's familiar with this and take a look at what the whole picture would look like in the future.
Would it be possible to, the amended plat be as a condition? Let
I don't think so, because if we go ahead and approve the subdivision, that's going to get recorded and possibly lots could be sold before we ever got to the amended plat.
I don't see any way of remedying this without amending the plat, and so you're faced with 3-month delay regardless.
No,
Have it.
no, if they do the easement, they have the ability to leave the road where it is, move it a little bit, make it accessible for Mr. Mendoza and his subdivision. It doesn't hurt anything that is allowed right now. If we're going to amend the plat, it cleans things up for the future. It doesn't change what we're doing today.
I just wanted to point out on this easement that they're talking about, if that was dedicated to Park County and the general public, we have the option to do whatever we need to do down the road. A similar case is on Sage Drive. Sage Drive is not all completely within the platted right of way as far as the structures and stuff, and we have separate easements that are not part of the right of way.
It just-
So there's certain things like this, but if they dedicate it to Park County and the public, we have the option to look at things down the road. As as far as that and getting landowners on board.
Okay.
That negates the need to.
For now, yes.
Regardless of,
Yeah.
so what you're saying is then we can appeal to amend the plat regardless of whether they have 6 landowners or not.
If they choose, yeah, if we choose to, we're gonna try to clean it up.
Madam Chair? Madam Chair, can you hear me?
Our planning director is trying to weigh in and we cannot hear her.
Can I send you a text
Are you
message?
muted?
No, I'm not muted. Can you hear me?
We can read what you're saying.
Lamar's checking here too, but we're not finding anything. Joy, if you can hear us.
Yeah, I'm trying to use the chat.
Okay. Trying to use chat. Okay.
That's why they're working on it. So in a sense, manager, go forward with amending the plan. Mr. Hanson is okay with that, as far as I understand, and he's going to be the major landowner that this is affected. So the county would be taking the risk for damages from anybody that could send, appeal it, right? Is that correct, Ben?
I guess my point is, if it's granted and it's dedicated to Park County and the public, the landowners aren't harmed as far as access, then they have access.
The only one that is affected is Mr. Hanson.
That actually reserves him access where
And
the
it's
road is.
benefiting him, yes.
Yes.
And I think he understands that.
Dedicated. Oh, that's Ben. Okay. Joy, we're still not seeing anything. Oh,
This still doesn't fix any part of the road.
Yeah, we
I don't
haven't
think
got
there's
to that
anything
issue as
that's
far
gonna
as
fix
I'm.
it for you.
What's that?
I don't think there's anything that's gonna fix it for you.
Yeah. But, just saying.
Sorry, go ahead.
They constructed it. Talked about it. $58,000 to build the turnaround. Another $50,000 to do all Marlin Road. That's not.
But it needs to be.
The lower part.
well, it's a conversation within the subdivision. They're responsible for it. It's not a conversation with Park County.
But it could be because of the subdivision.
No.
Why not?
Because they would have access and they have an easement and it's dedicated to the public, but it's not a county road. So we don't do maintenance. It's up to the homeowners association and the landowners in the subdivision to keep their road up for use.
Yes, but we always have the option to stop development until it's brought up to the standards.
Oh, yeah, but Brian already gave them administrative relief for this subdivision. He's approved administrative relief for this subdivision.
We haven't approved the subdivision.
No, correct.
So we can make it a condition. And it can be discussed.
You want to go there?
Pardon me, yeah.
I
I mean,
understand.
it was been screwed up so many times, but there's 3 wrongs make it right.
There's where we're at. Gotta do something. Gotta do something, or we're just kicking this can down.
But I totally get, should it all fall to the Mendozas? But we can at least make some kind of approval on we call them on the improved subdivision improvement agreement to be part of, based on the approval. You come up with a damn plan that says everybody kicks in, or maybe you do 50%, everybody else kicks in the other, I don't care. What, but the fact of the issue, we continue allowing more development on roads that were not built, that we have these criteria for a reason. Once they
You got an
cross,
answer for us, Cody?
once they cross a certain threshold, they have to be improved.
I understand, but we're not talking to the rest of the landowners today. We're talking to a subdivision person with 2 lots. I don't know that we can put a subdivision, we can say they need to belong to one or get one going, but we can't say what the rest of them are gonna agree to do.
Yes, I agree with
Is
that.
that in that they would join so it's already in their subdivision? They would join a road improvement.
And the road improvement situation needs to be resolved before the lots can be sold.
Chair, I think we're getting too far into stuff. That we should be thinking. Can't force anybody on that road to do anything. Doesn't matter. I don't even know what the road is. That's what I said. We can't force them. Right now, we have, correct me if I'm wrong, but the Mendozas have access to the road. So if we take into consideration what we did to it, this would be approved. They have access to the line. But what we have here is the subdivision, which cleans that up already. And are we getting too deep? Have a subdivision that would be approved on a normal basis, because they have access.
Right. That's why I said the subdivision was today's answer, but whether we want to clean up some bad county paperwork
Sure.
in the future is up to us.
Commissioner Stewart, I understand what you're saying, but if all subdivisions have a level of use on the access road. When they exceed a certain standard for a road bridge, they have to be built to a different standard. That has been bypassed numerous times, so it doesn't make it right to bypass it for further development.
Well, we have the most. We have landowners with 2 lots. So how much traffic does that increase?
I think Brian took that into consideration.
Where we at?
I'm good with subdivision with the use of the deed. Yeah, okay, county. That's a motion.
Second that.
A motion and a second to approve the Mendoza subdivision as requested with the granting of a 20-foot easement to Park County and the public.
I amend my motion.
Second.
And can I just clarify, that's a condition? That's an added condition.
And it is 20 foot, correct?
Correct.
The second we finish, right? Okay, yes.
At what point and where do we move to plat review? To me, the time is.
I think we need to sit down and have a discussion with our planning department on what this can and can't mean here, as far as what else is developable out there and how it would work and what it would take to do it. We need to get that question answered from the irrigation district or expenses. We need to take a look at the whole picture. So it may take a little time.
Okay, I just want to know if we can somehow include it, just simply because one doesn't fix the, just to have an easement does not fix the realignment. I mean, it fixes it going in, but it still exists on the rest of the property.
Okay, the motion right now is to approve the subdivision with the easement and the dedication. So that would take care of that. If you wanted to make another motion later that says we.
I think Ben kind of addressed what the county can do in this situation, correct? I think that's further discussion, but I think it's something that I would like to see us address.
Madam Chair, would that require a separate, as you mentioned, a separate motion? Or can it be, is it just administrative?
I could just talk to staff and our planning director is listening to the conversation, so she knows we want to take a look at this.
Okay,
We still have to come in front of you again for final plat.
You're gonna give us more headache. Okay, any further discussion on the motion to approve the Mendoza subdivision with a 20-foot easement granted to the public in Park County? Hearing none, all those in favor?
Aye.
Anyone opposed? Okay. Okay, thank you. Yes. Okay. You. Okay, we will make a note to continue to work on this when our staff gets, when the director gets back. Okay, the next thing on our agenda is final consideration of the Bryan appeal. This has to do with the septic system. Owl. That we sent a notice of violation. We've done this a couple times. Did with them, I think it was in June. Said we would make a decision at the end of August, hoping that they would replace the septic system. I do not believe the septic system has been replaced at this time. Is that true? Okay.
Madam Chair, I got to go out to the property right before lunch and view the septic system and the manure piles. Part of that, septic system working. There's no issue with that. It's going to get to a point where it's not going to be working. So, but I see that they put in their application, they paid their fees. There's an argument over some of the tests that have been completed, the perk test. They put it in 3 different spots. And due to the depth or whatever it is, maybe Lloyd fills in more. He's put in septic systems before. But, as far as the spout toward the top, it's completely clean. There's nothing coming out of it. I hadn't flushed their toilets. It was fine. Nothing was leaking out of the top. But it seems like they are moving forward, but they haven't done anything.
We do have a letter on record from DEQ that they are required to replace the system. That's all I can. Thoughts on the testing?
I have a lot of thoughts. Number one, we're looking at a violation for an unpermitted system. I don't think there's anybody's question, even the landowner, as to whether the system is probably in need of replacement, let alone or minimum. You can't do much repair because of the issue. I think from the beginning we all agree and know that this is a civil issue. The violation in question is for an unpermitted system. The unpermitted, which in my opinion does not apply here. The system obviously was put in before permits were required, so therefore it's not a violation. The discussion on the last hearing of a modification to the system required permits. Understood, but DEQ also agrees that adding cleanouts to a tank or the line for ease of service does not constitute a modification or a permit. We cannot override that. I have Doran Larner, the assistant engineer for the DEQ, research it, and there was nothing in adding cleanouts that constitutes a modification to the system by just making it easier to clean out with the added cleanouts. That's what our planning and zoning distinguished as a modification, which is not by the requirement of DEQ. So anyway, the violation in question does not, I feel, is unfounded. by legal rights and everything. I mean, if you look at the violation, it's for an unpermitted system, not whether it works or not, but whether it's permitted or not, and it does not require.
I understood that even before Wyoming, Clark County required permits, the state of Wyoming required permits. I wish we could get sound from our director who's working pretty closely with this one.
Well, I think, Madam Chair, I believe Cooley's are attempting to replace their system. Back to the perk test thing, I've read some of the correspondence between Joy and this Kimberly Perrine. Anyway, yes, most of the problems with not issuing the permit were miscommunication. Other than the perk test itself, you are required to do 3 consecutive tests in a row until you have the same number. And that's what even Kim Cooley's admitted they missed that in the regulations that they had to do. They thought they had to do 3, meaning 3 separate ones. And they are 3 separate ones, but each one has to have a minimum of 3. Usually the first one is a little faster technically, and so they used a different form. To my knowledge, I don't know that Joy has ever received the corrected form, which it can be used as, the application is very confusing. 6 years ago, it was trifold, now it's 43 pages. So the end result of the testing and the perk rate and the sizing is basically, it's the same as it always has been. It is confusing. But I believe that the Cooley's are working with planning and zoning to resolve that and get the permit approved so that they can replace it before winter. I see they're not. We got a letter here that they're not able to attend today for whatever reasons, and they're willing to comply and work with. So as far as violations today, I'm not in favor of pushing any simply because they're not.
But then so I think in order to clean this up, we need to get they appealed notice of violation from our planning. We need to get that cleared up one way or another, get it out of the way. And whatever it appears that they are moving forward with getting the system replaced, which is something we have to do. And you read the accused requirement. So I think that's
So, Madam Chair, then Lee, and you believe they're correct that it is to either revisit the appeal or revisit the appeal of violation.
you would have to uphold their appeal and that, or uphold the planning and zoning director's violation, one or the other. We have to do that. So we either uphold their appeal, and that makes the violation go away, or we say they're in violation. And
Well, Madam Chair, I'm going to stick my neck out here and I'm going to go ahead and make the motion to uphold the appeal for the violation because I do not believe that it is permitted system is the violation, and it is not fall under that because of its age. In fact, it is still working to its capacity. I don't know, but it is still working.
I'll second that discussion. If we're over the rebuild. So we already uphold it. No, the appeal.
So we left it hanging and said, we'll take a look at it. After August, we asked them to replace the system. August. And finally got the email started about 2 weeks ago as far as the perk tests and things go. And that's Director says responses does not have any communication from DEQ indicating that the modification does not require a permit. I also do not have evidence that the system was ever permitted. Required.
As required.
As required in past.
Madam Chair, your communications, Commissioner Teal, with DEQ. DEQ would send you adding cleanouts.
And you talked to the assistant engineer?
Yes. Yes, I talked to Doran Barner, and he took 2 days researching it before he got back to me. And to aid in the service of the system does not constitute a modification to the system.
I can agree with that. If you're starting to add legs, if you're starting to add legs.
Absolutely, or replace a tank.
Replace a tank, that's a modification of the system.
So we have a motion to uphold the appeal. So,
So now we've got it.
discussion on the motion. Like, it's not a public hearing, I'm sorry. Or,
Did not tell you.
I think we have that in writing.
Okay, you want me to put mine in writing, and I would be happy to give you his phone number, you can call him yourself.
It's up to us as a group, but
I know,
I
I'm
do
just
have a
saying,
DEQ
if
letter.
you want to delay this anymore, I brought his phone number specific.
I have a copy.
I will also mention that DEQ specifically said that I needed to talk with the county planner because they didn't want to get in the middle of it.
Because she's designated as their representative.
But bottom line is, show me in the regulations of chapter 25 where adding a cleanout is considered a modification requiring permit. You won't find it.
So, this is something that Chair, how did we get to the consideration of penalties if we didn't? Aren't we here for consideration of penalties? So how did we get this far without upholding, without denying the appeal?
It's consideration of, final consideration of creating.
Oh, okay.
No.
Oh,
Not
okay,
penalties.
all right, fine.
If we uphold the planning director's decision, then we'll move towards the next step. Kind of got it a little bit bogged down last time because we were considering their appeals. We had to say, go ahead and replace the system. Start on getting the system replaced. And so that probably should have just considered the appeal at that time, but we get two different tracks.
I can read you this for Doran's.
Okay.
I did not tell him that he would not need a permit. He attempted to get that determination out of me, but I deferred to the county, stating that under the delegation authority, it was the county's responsibility to determine if a permit is requested. I did tell him that I felt he was trying to put me in the middle, however, in the middle between your office and the state, and I would not do that. He stated I was a chicken, which I ignored, but didn't appreciate. It seems like he is trying to do an end around to circumvent your office's authority and or the rules. This was sent to Joy on June 24th. So that's the email. So I don't know about modifications. I understand the clean out concept. I mean, I don't have a problem with that if that's what this said, but that's not what this says.
Madam Chair, if I could, I have not seen that email that was sent to Joy from Doran. However, he's not wrong because I believe our planning and zoning was wrong. Our director stated that interpretation was from the DEQ. That's on record in our last appeal. That in fact was not. It was untrue. Nobody from the DEQ office told Joy that a modification, adding cleanouts was a modification. If her department wants to take it upon themselves to consider that as a major modification requiring permits, then it needs to be put in our own rules. I know we have our own set, but we don't even have that in our own rules. An interpretation of adding cleanouts would be considered a modification requiring a permit. You can't just decide things. We have rules and we need to follow them as well. So my motion stands as stated.
Any further discussion on the motion? I was trying to read Joy at the same time. In my understanding, your motion was to uphold the appeal of Cooley's.
That, to the point too, though, that if we uphold this appeal, we stop working on it. So the important thing is they continue to work on this project.
Madam Chair, I would disagree because the appeal, DEQ has already sent a letter that says they have to replace the system. Whether the DEQ, we're on two different tracks. They are under a requirement by DEQ, they're under a requirement by us to replace their system. What is being appealed, what they appealed is that they're using a unpermitted system. So even if we say, no, if it's not an unpermitted system, I do not believe that changes the fact that they have to replace it. I am not willing, if that appeal says that they don't have, if upholding their appeal says they don't have to replace it, then no, we don't do it. But I do not believe that upholding their appeal means they don't have to replace their system. Because they've already been told by us, they've been told by DEQ that they have to replace it.
Do we know what the appeal specifically says? Do you have a copy of the appeal? Yeah. I just want to be sure. What it's stated. Okay, thank you.
Well, what's stated in the appeal would be in disagreement with what letters from our planning director said.
But I'm
They're
not-
appealing her decision, her letter, under my understanding, and I hope Joy can hear me, was that they are operating a permitted.
I'm sorry, I gotta lean in here. I was told by someone else that we need to lean into our mics. It's my understanding that your letter to them said they were operating an unpermitted system.
said yes.
Do we need to, this isn't a public hearing. We need to continue to have comments from, okay, thank you. Have a good day, ma'am.
Thank you.
Have a good day.
Excuse me, thank you. Joy, we're waiting for Jenny to bring a copy of the letter, just so we're, of the appeal request, so we're positive what the wording is to uphold or not.
And I'm going to ask you, Commissioner, do you agree that they have to replace their system?
I agree with the fact that, and I haven't officially seen that if Wyoming DEQ says that they have a failing, they're basing their failing system. I have a question on that too, because of what DEQ is basing, as DEQ basically decided, they're basing it on what was reported as sewage was running across the top of that. That has not been proven by anybody. I think they should have also the right to appeal it if needed, because the septic system is, they're agreeing to replace it. The problem we're having here is the fact that you're telling them to replace it when they want to replace it. And DEQ is telling them to replace it. They want to replace it, and I believe they are in the process of doing that. Now, I'm not in disagreement with the fact that it should be possibly, because simply because of its age, and all septic systems are failing the way you put it in. This one being 35, 40 years old probably has outlived its life. no question about that. So they're wanting to repeal, but I just don't like government coming in, whether it's us or DEQ, saying you have to do this based on a complaint from a neighbor.
You want me to read the letter? That went from planning and zoning to,
No, this is the violation. But you can read it to the rest of it.
as evidenced by multiple letters, emails, conversations between you and the planning and zoning department and staff. Staff has attempted to work with you to bring the subject property in compliance with county and state small wastewater system regulations. Since late 2023, unfortunately, you have not provided evidence of a permitted small wastewater system to serve one or more structures on the property, further making an unpermitted repair to an existing unpermitted system is not a sufficient action. As such, the Planning and Zoning Department has determined that the property is in violation of Park County, Wyoming 2015 Development Standards and Regulations and the Park County Small Wastewater System Regulations, and does hereby put you on notice of the violation. Violation, nature of the violation, unpermitted wastewater disposal, application provisions, DSR, potential fees and penalties, enclosure B, corrective action, and time unit for compliance. Within 7 days of receipt of this notice, submit a complete small wastewater permit application packet to the Planning and Zoning Department. Within 30 days of receipt of a permit to construct from the P&Z, commence construction of a permitted small wastewater system on the property. Failure to complete the corrective actions within the specified time limits will result in a notice of consideration of penalties to be scheduled before the Board of County Commissioners at a date and time certain. Appeal. Should you disagree with my decisions, you may file an appeal according to the Chapter 1, Section 16, WSR. Note that appeals shall be made within 20 days of any final decision by filing a notice of appeal with the Board of County Commissioners. Please let me know if you have any questions or concerns. So that's the notice of appeal that went to them, and it clearly says that it is for an unpermitted system. It does not talk about any part of it.
So we uphold their appeal, we're just saying that their system is not an unpermitted system. I still believe that they're.
This is really how long do we let that go? How long do we let that go? When they've been told by our planning and zoning to replace it, they've been told by DEQ to replace it, are we involved any further?
That would, how long does DEQ give you if it's a situation like this? If we,
We're the delegation for DEQ. And I guess it would be up to our planning director to whether they are working in good faith towards replacing the system or not. And then it would be a different notice of violation for not complying with our DEQ.
I
don't think we can.
Madam Chair, I 100% with Commissioner Livingston. I think
Get that all done. It is recorded.
yeah, it is recorded. The violation is one of them. Now, whether they want to, I think they truly need to get an official letter of a failed system. They have to make it official, in my mind, that from planning and zoning, they already have one from DEQ, but you just said it needs to come from us. We police that. So in my mind, I mean, I wish Joy was here and she could weigh in on this, but I think that two separate kind of issues right here. And I think it needs to be in writing that the county feels they have a failed system. If that, isn't that where you were going with that?
That's where I'm going.
Then the clock would start.
I think that has been communicated to them and by our staff plus the DEQ, but that's something for Joy to answer when we can have a conversation about it. That has happened. So right now, have a motion on the floor to uphold the appeal for a unpermitted system. Any further discussion on the motion? Hearing none, all those in favor?
Aye.
Anyone opposed? Motion passes. Okay. This may not go away.
I think it will come home, 'cause
Okay. Moving on our agenda. Is Karen here?
I saw her ducking around.
Oh, okay. Probably. Nine. I have no idea. I just looked it up. Well, you didn't get a break. You got 4 minutes to get coffee. Okay, Karen should be here somewhere.
I did.
Yep.
Yeah, okay.
Oh, Scott will be back in just a second.
Now, we can condition this one on, we can put conditions on this one.
Yes, yeah.
Good. You gotta have the sample provided, the alcohol being. Don't believe that I can make an informed decision on this.
Sarsaparilla. We're gonna say sarsaparilla.
I
Okay.
did get, fellow commissioners, I did get a text that unless you're leaning into your mic, we're garbled,
Got that too. Thank you.
and it would come from there too.
Okay, so what I would say, the next thing on our agenda, Karen Horn, Library Director, and fellow library people, consider allowing alcohol to be served at a night at the library event. So thank you. Go ahead.
Hi, I'm Barb Francis. I'm the chair of the Library Foundation Board. And thank you for your time, number one. And number two, I miss you guys up at the library. You're not coming in for lunch anymore, coffee. So please come back. I liked it when your meetings were up there. That was great. So we are again having the night at the library on October 19th. And we would again like to serve alcohol at this event. We had a great successful event last year. We're hoping it'll be even more successful this year. We did not have any problems alcohol related. We had a bartender who had all the licenses in place and it was very successful. So we would like your permission to again serve alcohol at the night at the library on October 19th.
Madam Chair, just, is there a section for it that you have set up, or do they wander around with alcohol? How does that work?
So there is a setup bar with the bartender there, and then they have access to all areas in the library. We did not have any problem with people leaving the library with alcohol. It was all contained within the library.
Just where there'd be a wine glass in the children's section or something?
Yeah. And we spend lots of hours cleaning up afterwards, so. I'm sorry. This is Marilyn Ward, and she's also on the board with me. And you know this one over here, so.
This one.
Yeah, we do know that one. Okay, anything else? Thoughts, concerns?
Madam Chair, move to approve.
Moved and seconded to approve the request for consideration of allowing alcohol to be served at the night at the library. Any further discussion? Hearing none, all those in favor?
Aye.
Anyone opposed?
Thank you very much.
Have fun?
Enjoy it.
All right,
Hope to see you there.
okay. Oh, all right. Okay. Wow. We have one more thing on the agenda, but I think that the gentleman that was pursuing this may call in, so we'll give him a few minutes.
The way I gathered, they want to put building villas over there, so they're gonna abandon those lots. But then there must be a process to abandon those lots and turn back into things.
Unsubdivided.
What's that?
Unsubdivided.
Basically, it's what it sounds like is, but they need to come in front of us.
Well, the only way I can see that you do that is if the developer still owns that lots. They want to come back and open space.
The developer doesn't own anything anymore.
Yeah.
Well, I mean, I'm sorry, owners have.
Yeah, the owners will.
Lots.
So that's why they need to come and talk to us, because those lots were held
Like in a escrow type of weird situation.
weird situation where they weren't owned by an individual. I think. Yeah. So they have to come in front of us and talk to us about what they want to do. They also might need to put us to work. And a lot of situations.
She's a woman. What?
Oh,
Yeah, for messages like that. Ask them to.
We have to go to Rock Springs.
well, yeah.
Somebody,
That's
stand
what I
up
think
like
it's
this.
passed. So you can see on this. sheet over there, thank you.
I'll just let Holly know. She won't be back on Monday. She's got her computer with her. Oh, she didn't tell me that part. Yeah.
I think it's, yeah.
Oh, jeez.
New.
No, I was gonna say, we can probably find.
Started on the first. Yeah. He probably started, archery started on October 16th. I do believe it more. What's that?
There you go.
Just one. I.
What area?
Three.
For the first time in most of the summer.
So did you actually get it?
At where at the South Fork of Wood? Yeah.
You get up there, you don't have to go on the calendar. Just work right around the calendar. Class. Stop on through the rest of your community. Work on it. Sure. And also to the. South. March, you get up there, we went up there. Sunday. And it's a year or something.
It started off.
They got a meeting at the highway now. Right all the way up. To switch that. Kind of a trail there. Whatever, it's not the name.
Yeah.
And there's a gate.
Well, none of it has to do with what.
So you can't go the last half mile.
You can't play that.
It's only what you say. Well, Tuesday through Friday. You see what the forces do, so it's like, yeah, tomorrow, so look at hours. Oh.
That'd be cool.
Well, some of the machines
Tell me it's cool, but then it went down.
will actually figure out.
There's your yard there in the morning, there's all these people coming up and looking in the windows. It's not closed. It's, you can rent it, so you preserve it. Just to have a look around.
Nice.
And they took it down.
Might not want to see me at that or do that.
But it doesn't affect the current skill.
What's her email address?
That would be a good reason. That was like an Aflac situation.
Oh, that's what it is.
Yeah.
Yeah.
Like the Aflac would set up
She
one,
was the
a
gal
mailer.
she keeps wanting us to put that insurance, allow the,
Uh-huh.
well,
That was the, wasn't it the snowplow hit the car and how, throw gravel up or something?
yeah,
That was one of the stories.
and they paid out a claim on it. She's one, that I think, if that's who it is, it's the one that's come in front of us and wants us to be able to provide this to the employees or allow her to come in and tell the employees.
I think we said she couldn't come in, but we could send her a mail.
So, I'll throw one of these in there, we're talking about sunburst, snowplows, under that.
Yeah.
Have to walk down. Go around and go down there. Also, try to get in the snow. Maybe get to the trees, put it back down. Go back to 4 time I did, the social snowplows, I don't know if y'all what he wants to find. It will be so bad. So the next couple weeks later, I'm standing there, side room, just getting it.
Yeah. We're always on.
Oh. Have to go through the bus first, leave one of the buses, and then come out.
You wonder why we have to have people on the buses now.
That's right, Travis.
Yep.
It's, I'm still on that.
What is it? Yeah. I think he is.
So. Yep. Yeah,
Really?
He was on our, oh, I should put it against him.
I didn't look through all of it. Oh, yeah, I never did get that good.
Same with Hanson up in Star Valley.
WWDC. Executive session. just kind of on a break waiting until 11, because like Kyle said he might try to join us, but I don't know. Oh, the wall's gone. The bar's playing Molly today with the computer, so Molly's on vacation.
Oh,
He loves sitting through our meetings. It makes his day.
Always on vacation.
Do what thing?
Always on vacation and the horses playing.
The horse playing with the computer.
Oh,
Still Polly's on vacation. That's why I always love watching these with the legislation, because there's some interesting ones that pop up every once in a while.
that makes sense.
Mhm.
Yeah. Well,
Does
this
that-
morning he's Commissioner Mango. Mango.
It's because Lloyd wasn't enunciating.
We're on mute, so. Now it picked it up.
Oh, that's good. I can sit over and say whatever I want. I know. Yes, if you didn't realize it. Oh. Yeah, that was when I quiet.
Yeah, because they can use that wall. And we could put a calendar underneath it.
Are you here to research state statute? You know them by heart, so you don't need to research them. So I'm gonna put you on the spot. So, just because you are our leading expert. What's shaking your head? I'll give you a head start. I give you a head start, 11-21-101 through 113.
Is it 11 something?
1125.
11-25-101 through 113.
No, that's, yeah, well, that's the old one. That's 2 years ago. The newest ones are 1125-201 to 1125-209. They renumbered them. They changed them and renumbered them.
Oh, they did. So does this,
Our resolution that we
Resolution?
received from him Friday night at 5 has the new numbers on it.
I don't have to show that.
Probably right, because I had no idea how it worked after Molly left.
Okay, so they're a different number. That's not 101. What did you say?
1125-201 through 209.
201.
And 1125-101, which we have that paragraph on here. So it is 11 o'clock. So on our agenda, we have a request from 307 Horse Racing for a ballot initiative for the commissioners to approve a ballot initiative, and they sent a copy of a proposed resolution. If you remember correctly, we did this 2 years ago. We did a ballot initiative for the same thing, and it was declined by the voters of Park County. They came back to us this spring, which they can come back every 2 years. They came back to us this spring and talked about putting it on this fall. I did not hear from them until Colleen and I received a draft resolution about 2 weeks ago. Colleen sent it back to him because it was listed as Converse County. So we did get that fixed. And then when I received the copy again, I did forward it to our county attorney, who has reviewed it, found some statute number changes. So those needed to be changed. And one part of the wording was pretty unclear. So I asked Mr. Ridgway last Wednesday to work on that and talk to the county attorney about the wording. And he sent another draft resolution at 5 last Friday night. That's what I have here. If you would like to see it, the county attorney has reviewed it and given us some information. So with that, if you would like to discuss what this says, it's approving a question regarding parimutuel wagering to be placed on the 2024 general election ballot in Park County, Wyoming. This is whereas the Board of County Commissioners of Park County, Wyoming have received a request from 307 Horse Racing Inc. of Casper and Gillette, Wyoming to place a question on the 2024 general election ballot asking voters to accept or reject parimutuel wagering in Park County. Whereas statutes 1125-201 through 1125-209 address parimutuel wagering in Wyoming, and 1125-101 states no parimutuel event shall be held in any county until the question has been put to the people of the county to accept or reject parimutuel wagering. If the election fails, then no other election shall be held for 2 years. Now therefore be it resolved, the Park County Commissioners hereby instruct the Park County Clerk to place the question below on the 2024 general election ballot. Shall Park County, Wyoming allow parimutuel wagering only on the following activities? 1, live event horse racing to include quarter horse, thoroughbred, and other approved races. 2, simulcasting as defined in Wyoming Statute 1125-102A7. And 3, historic horse racing terminal/machines as contemplated by Wyoming Statute 1125-102A5. There's check marks for parimutuel wagering or against parimutuel wagering, approved and passed this day if we choose to do that. That's the resolution that is before us.
Madam Chair, question for staff. As far as getting a ballot initiative on the ballot, what is the deadline for that?
Today.
Today is the deadline?
Madam Chairman, Commissioner Mangold. So September 5th is,
Identify yourself, please.
my apologies. My name is Hans Odie. I'm the Park County Deputy Clerk, first Deputy Clerk, County Clerk. And with me is Katie Johnson, our Park County Elections Deputy. And Madam Chairman, Commissioner Mangold, the certification date for candidates to be certified to the county clerk by the Secretary of State and by municipal officer or municipal clerks is the 5th. And we go with that date as the time when that would be our drop dead date to get something like this on the ballot. Thursday. So this is your last opportunity to approve something like this.
Madam Chair, I don't mind letting the voters decide on a project like this, but I think it would have to have our county attorney approval to actually make it fit into our rules and such. So I think if we pass this, it have to be pending a county attorney approval.
To form, remember.
To form. Correction, to form. We want to make sure that we're not putting something on the ballot that's illegal or doesn't fit Park County. So I believe that it's to form. I don't mind letting the public decide it. They decided it 2 years ago. And maybe if they decide it again, they won't keep trying. So
I believe one of the questions that comes to mind for me is I know some other counties have approved this and they've had it on their ballot and they are working through it. But I also believe that I've heard some discussions at the Wyoming legislature about how these are handled in different counties and that there's no continuity right now between how things are working and that the legislature is possibly working on some solutions similar to how these places would be, use the term permitted, whether it's an SUP or in the county or in the city limits, similar to what we do with liquor licenses. They would have an application and a process to be able to do this type of thing in Park County. And my thoughts are kind of to see what the legislature does with it this year, but that's just me. I think we're going to change some laws and keep moving forward. Other input?
I'm just got, Madam Chair, I do agree with the comments that the county attorney has, and I do that resolution that it's written.
Madam Chair, that's it.
Which one?
The one from county attorney.
The resolution states one thing, but I don't think we can limit it on the ballot.
That is part of the discussion. And we did kind of clear that paragraph up a little bit from what we had a week ago, but it does say only on the following activities. But by statute, we're not sure that we're allowed to limit that, even if it is on the resolution in that way. If our county approves pari-mutuel racing, it approves pari-mutuel betting, I guess, put it that way.
Madam Chair, that's my concern too, because you have the updated version of the state statute, but looking at this other one, the statute is read as and such other activities covered by these provisions. And that's what my question was going to be to Mr. Hands as to what are these other activities?
And there's multiple. That's a conversation that I did have with the county attorney on what types of things, and that was one of his concerns. And it's not clearly spelled out in this resolution. And I'm not sure that us approving it different from 307, what they have around the rest of the state, I don't know how that would work.
Yeah, Madam Chair, again, I don't believe that we can limit what is allowed by the state statute unless the state statute, which I can't read that in here, gives us that authority. And I don't see where it gives us the authority to limit what types of pari-mutuel wagering we will allow and not allow. Whether we put it in resolution or not, I don't believe that would hold water.
Madam Chair, one of the other activities are their main moneymaker, which are the real games. Yeah, that's basically a large part of it. They don't mention the real games, and there's different kinds of real games that are offered by some of these horse palaces or gambling places. I mean, they were pitching us a couple of years ago, 307 horse racing, who put this resolution together. And they waited till a minute before 5 o'clock before they brought this in. I don't know why they would do that, or if there was a reason to do that.
I will have to say he did apologize for being so late. It was just his timing.
Madam Chairman. So the statute is extraordinarily vague.
Imagine that.
No pari-mutuel event shall be held in any county until the question has been put to the people. It does not refer back to election statute. Generally something like this. I'll use, for example, the lodging tax. I mean, we had ample time to have the public comment on placing that on the ballot. It wasn't held until 1 minute before 5 on Friday night. And this statute, we've conducted this election before. We didn't initially know exactly what we were doing with that. And it has not gotten any clearer in the last 2 years what we're supposed to do and how we're supposed to conduct this election. It doesn't say in the Principal Act you shall follow procedures from 22-1-101 at SEC, which is the election statute. It doesn't say you'll follow how an initiative or a referendum is supposed to be followed and done in elections. I mean, an initiative or a referendum, there's a comment period and an advertising period before you ever consider this. And so I just, this is a decision that you as a board need to make, and we will follow through with it. However, it feels rushed, and it feels like you're being pressed. That's I'll just say that from our office's standpoint.
Madam Chair, I typically tend to believe this should be go to the voters. But I think with what Mr. Odie and Mr. Swart raises, it's pretty alarming that we can get something in there that we can't control, or we don't know what's going to happen. And I think, as he points out, the voters should be very uneducated. And when they go to the polls, we're not going to have a statute in front of them to see what it even says. So I think that I for one can support.
Madam Chair, call the question.
No action.
No action.
That's what you mean. Yes.
Mhm.
Yep.
Is there a motion on this issue? Hearing none.
Second.
Damn right I am.
No, I'm in Mango.
Mango?
Mango.
Mango?
Mango.
Mango?
Mango.
Mr. Mango.
No, I second it.
Thank you, Hans. Thank you, Katie.
Yeah, thank you.
On the 16th.